Good morning, everyone.
Good morning, Your Honor.
Morning.
Welcome to this morning's oral arguments before the Kansas Court of Appeals. I'm Judge Sarah Warner, and I'm joined today with by Judge Amy Klein from Wichita and Judge Angela Coble from Salina. I'll be presiding over today's arguments, which basically just means that I'm going to be keeping track of your time. We have one case on this morning's docket, which was actually part of our May docket, where the court submitted some questions to the parties, and the parties have submitted some additional briefing and have appeared today for argument. So thank you to counsel for engaging in this discussion with us. In preparation for today's argument, we have thoroughly reviewed the parties' written submissions along with the court record, and so we are very familiar with the case. We encourage the parties to just jump in to their argument because we only have 15 minutes per side. So with that, I call case number 476 from Sedgwick County, State of Kansas Appellee versus Willie Joe Emery Appellant. Would the parties please state their appearances?
Sean Randall of the Appellate Defender Office on behalf of Willie Joe Emery, present and ready for argument.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Welcome, gentlemen. Mr. Randall, would you like any time for rebuttal?
Yes, please, Your Honor. 3 minutes.
3 minutes are granted. With that, you may begin.
Thank you, Your Honor. As the court indicated, it's very familiar with the facts and procedure of this case, so I'm not going to belabor the court with those points. I think we're probably all aware that we're really here to discuss, I think, 6814D, its contours, what it means, and what this court's supposed to do when someone's challenging criminal history for the first time on appeal concerning an out-of-state conviction. I think that's generally what we're here to discuss. And my position, Your Honor, is that both based on the plain language of the statute and also on the legislative history of the statute, I think it's very clear that the legislature's intent was really two things. Specifically in this case, or what's important in this case, is that I think it most certainly gives this court authority and directs and allows and says that it can and should consider out-of-state convictions. I think it also just shows the overarching intent that the legislature wants to make sure that the courts get criminal history scores correct. I mean, they're one axis of our sentencing grid and largely determine how long my clients are going to spend in prison. And so I think the court or the legislature was saying we want to get criminal history score correct, and we want to correct any errors in criminal history at the first time that they're brought to the court's attention, even if that is, on appeal. Now, obviously, in this situation and in appeal, when looking at the statute, it does indicate that that the burden shifts to us and that we're responsible for designating a record showing prejudicial error. And I think that's exactly what we've done in this case by providing certified journal entry copies of Mr. Emery's Tennessee conviction to this court. Now, when we're talking about the plain language of the statute, I think it's important that I should maybe note to the court that I agree with the state on two things. One, the statute should be read in para materia. We have to look at all of the statute and not isolate one sentence to the exclusion of the others. They're supposed to be considered together. I would also agree with the state that there is a difference between Kansas convictions and out-of-state convictions. But when you look at the statute, specifically the fourth sentence that the state, I think, really is trying to hang its hat on, okay? That's the one where it says that the appellate court can take judicial notice of journal entries, verdict forms, plea agreements of Kansas convictions. And that makes sense. I agree with that. I mean, this court is very familiar with what journal entries and verdict forms and plea agreements from the state of Kansas look like. But all it's indicating and providing this court the authority is that you can take those records and those things through judicial notice. But judicial notice is not the only way that this court or any other court has ever received and looked at and reviewed documents. And again, in para materia, if looking at the sentence right before that, what it says that Mr. Emery has to do, what the appellant has to do. It says that he shall provide or may provide the appellate court with journal entries of the challenged criminal history that were not originally attached to the criminal history worksheet.
Counsel, but that sentence doesn't say anything. It just says journal entries. It doesn't say anything about these other documents that you have submitted. Doesn't that indicate an intent by the legislature to draw a distinction between journal entries on the one hand and things like an arrest report on the other?
Well, I think a journal entry is I mean, what are journal entries or journal entries of judgment? What I've provided this court is a document that says judgment. And it lists when he pled, what he pled to, the statute that he violated, the sentence that he received, all the things that a journal entry includes. And so I would submit that this is a journal entry of a judgment. That's exactly what's been provided to this court. And again, I think
but you didn't just submit the judgment, you submitted some other documents as well.
well, that's
Can we consider those other documents, or are those documents that need to be considered by a district court?
I believe the court can consider all of the documents.
Okay, and what's your basis for that assertion?
Because the statute does reference the other types of documents that this court can consider. And again, I think when we talk about what it can consider, the operative point, I think, in that sentence that specifies Kansas is the fact that it's just saying that the court can take judicial notice of those documents, which I think, again, makes sense. But it doesn't say that the court shall completely disregard and not review or not look at other documents. And again, pursuant to the statute, it says, I have to provide them to you. I've done that. I've designated a record. I've provided you certified, journal entries and copies that, again, show it everything that a Kansas journal entry would do. I would also note that in that same sentence that I'm referring to, the third one, it specifically indicates that the state may provide this court with journal entries showing a lack of prejudicial error. And they've provided nothing to this court to indicate that my documents are in any way not to be trusted or not true or shouldn't be.
Counsel, here's what I'm having trouble with, and perhaps you can help me. So I understand your argument with regard to the third sentence, but let's say that I agree with you with regard to your interpretation there. I still don't see how that allows us as an appellate court, not a court that makes findings of fact, to look at other documents. So judicial notice essentially alleviates the evidentiary burden that otherwise would have to be carried at the district court level. And that didn't happen here. And so I'm having a hard time figuring out what an appellate court would do with these other documents.
I mean, in this case, perhaps the other documents, at least in that I've submitted, the arrest reports and other things along those lines, may be considered extraneous. I mean, I wouldn't concede that point, but I could see the courts, it only says journal entries. But I have provided a journal entry. I have provided a judgment that lists all of those things that journal entries include. And so, I mean, if the court only wants to look at one document, I'd say the one that I've provided comports with the statute, and that's what this court, can and should consider and look at. When talking again about only Kansas convictions and things of that nature, I think it's important to note that every time that we or this court or the Supreme Court seems to be hearing a criminal history challenge for the first time on appeal, of course it's dealing with out-of-state convictions. I mean, Steiner was Arkansas, Obregon was Florida, Wettrick was Missouri. I think Buell was Florida as well, and maybe Moore was Oregon. And now here we are with Tennessee. That's what this court's going to be challenged with, because again, Kansas ones are simple. We look at them, we get them. They're easy to acquire. But in the situation where they're not from Kansas, yeah, there's a little bit more work on the appellant, which is contact the Obion County, Tennessee Circuit Court, get certified copies, have them sent, and provide them to the court. It doesn't say anything other than just provide, which is exactly what I've done, I think, in this situation.
Counsel, I'm looking at this journal entry that you've provided, and the only difficulty here is that the journal entry from Tennessee doesn't say which statutory subsection the conviction was under. Is that a problem?
I don't believe so, Your Honor, and I'm glad that the court, brought that up. I think in the state's brief, it said no less than 3 necessarily involved the presence of another person. We can look at all 9 of the different ways, but I'll focus and start, I guess, with at least the 3 that the court pointed out, or I'm sorry, that the state pointed out. I think the first one was falsification of information on a Tennessee Bureau of Investigation form. I don't see how writing down false information on a form necessarily requires the presence of another person. The other one's not turning in a TBI registration form. Again, if I just sit at my house and don't turn in a form, that doesn't involve the presence of another person. And the other one, was failure to notify law enforcement agency upon reincarceration. Well, if I just sit in my jail cell and don't use my one phone call to call a law enforcement agency, then I haven't necessarily involved the presence of another person. I mean, I think in any way that you look at the 9 ways that this can be violated, including the 3 that the state specifically pointed out, none of them necessarily require the presence of another person or satisfy any of the other 7 things that are listed, I think, in 6811. And again, particularly in this case, I mean, we know what he specifically did, which was not notify law enforcement within 48 hours of changing his residence. That certainly doesn't require, again, the presence of any person either. And so, no, Your Honor, I don't think it's a problem that the specific subsection is not listed in the judgment, because no matter whatever subsection it was, none of them satisfy the requirements in 6811.
Counsel, what do we do with the Tennessee case that you cited that said the statute is a non-inclusive list of examples? So then we have potentially other examples. How does that work into our analysis? Or potentially other ways the statute could be violated?
I think 6811 uses the words necessarily proves the presence of another person. And so by requiring the elements to show that and looking at the elements of the offense, you don't have anything that necessarily requires the presence of another person, Your Honor, regardless of whether that be the 9 enumerated or some amalgamation. I think this provides a nice transition, Judge, what you're talking about, to discuss, I think, Obregon and how we all ended up, with this statute being enacted and written the way it was, is that, the decision in Obregon was kind of the thing that you're pointing out, is that it doesn't specify the subsection that this person was convicted of in Florida, I think it was, for burglary, if I remember correctly. And basically what the state says is, look, in that situation, maybe it was scored correctly, maybe it was scored incorrectly, and so we need to send it back to, we need to send it back to district court. And then they were to prevent the flood of remands that the court was going to issue, where people were going to go back and then the court's going to say, well, no, it was correct, and you get the same sentence that you have. Both my colleague's office and the Kansas Association of Criminal Defense Lawyers went to the legislature and testified in support of this bill to fix Obregon, so that they say, no, if you're going to challenge it for the first time on appeal, defendant, you've got the burden, you've got to designate a record. If you don't do so, we're going to dismiss this, and you've got to designate a record showing prejudicial error, which again is what I would contend that I've done. If that was the intent and was only to fix Obregon, then the state's position wouldn't fix Obregon, because it would still be an out-of-state conviction that the state seems to be arguing this court can't consider. I mean, also, I did talk about the legislative history, and I think that was one thing. But I mean, the other thing is that when you read through their testimony, neither the Attorney General's office nor the Kansas Association of Criminal Defense Lawyers ever mentioned that the statute was only to apply to Kansas convictions. I mean, if that was the state's position, or anybody's position or intent, I can only assume that it would have been mentioned and said and specified as such during the testimony in support of this bill.
But counsel, when we look at legislative history and we look at comments about a statutory intent, aren't we normally looking at the enactor's intent, at the legislators, as opposed to any number of people who could be testifying for or against the statute and have an intent that could be completely separate than the legislatures?
Oh, certainly, Your Honor. Yes, the the legislative intent kind of canon of construction is, yes, looking at the legislature, not a supporter or proponent or opponent's, testimony or intent. But certainly I think this court can and should and has in the past, when looking at legislative history, talked and looked at testimony that's been provided. And again, in this case, I would indicate that the only testimony that was provided was both in support and both mentioned this fact. And so there didn't appear to be any opposition that was filed indicating that. And I would contend that, again, the testimony of the parties has certainly been considered and can be considered when looking at legislative intent. And again, I think legislative intent is one thing to look at, but as this court knows, that's only appropriate when the statute's language is ambiguous. And again, I think I've argued specifically and sufficiently that I think the plain language of the statute is clear, and it says what the court can take judicial notice of, and it also says what I need to do when the court can't take judicial notice.
Counsel, we're at the point where we are past your 12 minutes, but I want to make sure that I give my colleagues an opportunity if there are other questions. Are there other questions from the panel? Okay, and then Mr.
I apologize, Your Honor, I didn't have.
It's fine. We had lots of questions for you. So you will still have your 3 minutes for rebuttal.
Okay, thank you very much.
You're welcome. Mr. Gillette, you've got 16 minutes.
Good morning, Your Honor. Thank you very much. And I appreciate the court's willingness to accommodate both myself and opposing counsel having Supreme Court arguments at the time that we had originally intended to have this argument. So we do appreciate the accommodation. I want to start off by reasserting that the state's position is clear, that we believe that the plain language of this statute is clear and that it is intended to be restricted to Kansas convictions. And any type of look at legislative history obviously supports that position. I think this case itself ultimately ends up illustrating just why this statute exists.
Counsel, if that's the case, then why is it that the fourth sentence draws a distinction between, say, Kansas forms and that relate to Kansas convictions and implicitly other forms for purposes of judicial notice, but there is no such distinction in the third sentence?
And I think there are two things, I guess, that I would say to that is that fourth sentence refers to such journal entries. It's clearly referring back to the first and narrowing the scope to specifically those from Kansas, as well as other documents that Kansas courts are well familiar with and are perfectly happy taking judicial notice of. I think the second point I would raise in regard to that is the question of prejudicial error. There are certain instances where perhaps, and this is as much as I would concede today, where perhaps the parties could look at a journal entry from out of state and just concede an error on appeal. That's not an issue that would need to come before this court. But the question of prejudicial error is ordinarily one left to the district court. And to demonstrate prejudice on appeal, it would have to be conclusive, whereas this statute clearly leaves room for remands if there's a reasonable question.
Of course, but this statute also, that third sentence, allows for kind of vying journal entries, if you will, journal entries that are submitted by a defendant seeking, claiming an illegal sentence, and then journal entries that the state could submit to show a lack of prejudicial error. Correct. So could you explain to me how that is consistent with your argument?
This would, again, I think it would come down to if I think what we're talking about is that there may be potentially some ambiguity here, but I think before I move to that, it is hard to comprehend a situation where a journal entry, where the parties would be able to submit opposing journal entries that would do anything but pose a question that would trigger a remand automatically. So I don't know what to do with that other than I can imagine a hypothetical factual scenario, which is not what this statute is designed to address, where perhaps there was a journal entry that got filed and there was an error on that original journal entry and a non-protunct journal entry or an amended journal entry got filed. That's at best what I could foresee as a factual scenario that would trigger this battle. And even again, in that scenario, I think every single case is going to end up in a remand to clarify that. And that would probably be true even of Kansas cases, because who's to say factually which journal entry is last in line unless we actually take the time to look at the record. So again, I think that this statute was designed to make the easy cases easy, and this is not an easy case. I would note that this is the defendant's burden at this point to demonstrate that there has been some kind of an error. As I mentioned
Counsel,
before,
could you address the judicial notice provision? Are there instances where an appellate court might be able to consider something that's not part of the appellate record from an evidentiary standpoint and make findings, or are we limited to those provisions in the judicial notice sentence?
I believe that this court would be limited by the judicial notice provisions that are there, that are provided for in this statute, and that notice is again narrowed in scope to specifically Kansas convictions. And that, frankly, again, comes down to Kansas courts are familiar with our processes, our statutes, what our journal entries, what our documents all look like. We can look at those and generally be able to make a determination as a matter of law whether or not criminal history is accurate. It's not the case with out-of-state convictions. There are often, and as this case is full of questions of fact that need to be resolved by a district court. As I was mentioning,
when you've got a situation where the offender has the burden of designating the record, what is the court's prerogative to take judicial notice of other documents, or is there any prerogative to take judicial notice of other documents that the defendant didn't provide?
No. Burden has a meaning. It has to be carried, and that's something that a defendant would have to do, just as the state would have to do when the burden of proof is assigned to it.
So then what, I mean, we're all in agreement. We need to read this statute and all the sentences together. We've been parsing them out separately as we should, but then when we come back around to looking at it all together, I mean, what is your position on the purpose of taking judicial notice of any documents in this context?
And that was where I wanted to transition, is to, if there is any type of ambiguity in trying to read these two sentences together, and that is the at most that the state would acknowledge today, is that there might be, then we look at that legislative history, and the prerogative here is clear. And I appreciate opposing counsel's response to this court's order, because I think it proves the state's point from its original brief. This statute was passed to stop claims like those made and brought and litigated over years in Obregon. We sit here today, we're a year and several months after sentencing, and after the notice of appeal was filed, out of time even in this case. If this claim had simply been brought in the district court, it would have been litigated and over with long before now. And the problem with that is twofold. It is a burden on this court trying to weigh and wrestle through and wade through unfamiliar documents. That's partly why the state elected not to try to file any additional documents in this case. This case belongs in the district court. And it is abundantly clear from both the Attorney General's office, my office, the Kansas Association of Criminal Defense Attorneys, we want criminal histories to be correct. Opposing counsel and I are not necessarily that much at odds here, other than the procedural process. And the state's position is that the proper procedure is to do this quickly and efficiently in the district court. That's when we can look at these kinds of documents. We can sort out ambiguities. And all that the defendant's documents here do, respectfully, are prove that ambiguities abound here and that they need to be resolved.
Counsel, could you address this Tennessee statute? I'm interested in your argument that there are provisions of this statute that require the presence of another person, because I'm just not seeing it.
So would be referring, would be 21 the Kansas statute 216811 would require that out-of-state convict prior to be scored as a person felony if it involved, or if the elements of that prior require the presence of a person other than the defendant. And it goes on. In the state's brief, we articulated at least 3 versions of the criminal statute, which I acknowledge it is not exclusive. But these are crimes that are committed or would be committed when someone is registering. They would be face to face with an officer in whatever version offender registration takes place in Tennessee. I can speak to what happens in Kansas is that people go in, they meet face to face with an officer or a clerk at the offender registration office and complete their paperwork. That would require
I'm
the
looking
presence of a
at,
person.
like, for example, I'm looking at section 7, which I believe was a section that you pulled out in your brief. It's failure to timely report to the designated law enforcement agency upon release after reincarceration. Or maybe it was 6, one of those two. But I mean, failure to report, I mean, that's just a failure. That's not necessarily in the presence of another person. So I'm having a hard time connecting those dots. There were 3 sections that were um, emphasized in your brief, but I didn't feel like there was a lot of explanation, and that's what I'm looking for.
The 2 that I emphasized were, one would have been falsifying a registration form, which would be something you're completing with another person, as I understand the Tennessee statute. Failing to sign a TBI registration form, again, something that would occur in the presence of another person. And then the paragraph 6 that you're referring to, Judge Warner, is failure to timely disclose status as a sexual offender or violent sexual offender to the designated law enforcement agency upon reincarceration. So this is someone that has been taken into custody by law enforcement and is incarcerated and has then failed to report. Somebody took them into custody. The state would have to demonstrate, in order to prove this crime in Tennessee, that that person had been taken into custody and incarcerated. And that, we don't have machines doing that for us yet.
But it's not the incarceration that's the crime. It's the failure to timely disclose, right?
Correct, but the question is the elements of the offense, and there it would require proof that they had been incarcerated and then didn't do something that they were required to do. That would require the presence of another person. I would welcome any other questions on this, and I think what Your Honor, what you're driving at here is there is confusion. This Tennessee statute is not necessarily as familiar to us as many of our Kansas statutes. And again, I would point out in my opposing counsel's supplemental filing to this court, it proves the state's point, I think, in a number of ways, is that the first attachment listing a grand jury document doesn't have a case number on it. The next document, the date doesn't match what's on the purported journal entry. The general session court document that refers to a probation officer, the case number doesn't match the journal entry, nor does the date for the offense. The same thing on the arrest warrant. The one date matches the journal entry, none of the others do, and the case number doesn't match the journal entry. My point is, there are questions here. These kinds of out-of-state claims challenging out-of-state convictions, they're confusing. The entire goal of this statute was to stop wasting this court's time, stop keeping defendants in custody potentially longer than their sentence would ordinarily and legally require, and force these kinds of claims to be brought at the district court level where they can be promptly and efficiently litigated. That's it. The other thing that I would note is that at the district court level, a defendant would also even have the ability to waive constitutional rights and allow fact finding to occur if he or she felt that none of the conditions of 6811E could be satisfied. That is an option that would exist for defendants, and they can pursue that at their burden in the district court, not here. I would welcome any additional questions, but I think the legislative history is overwhelmingly clear here that if there is some ambiguity, then at most two things, and I haven't touched on this yet, defendants are required to, they're only allowed to attach things that weren't originally attached to the PSI. I understand opposing counsel's argument here that they made a request, but there are several things I would say about that. Clerical errors happen. Number two, the PSI here directly referred to, well, no, second, there are confidential portions of a PSI. Again, things may or may not get attached. And then the third thing that I would note is that the PSI in this case references a PSI from a prior case, and the request that was issued here may or may not have been broad enough for anyone to go back, get the official PSI from the 19 CR case, and get whatever documents may or may not have existed. So again, it's something that we can resolve at the district court, not here. And that is a basis alone, that alone is a basis enough for this court to not consider the defendant's arguments here. Final things I guess I would note in regards to opposing counsel's supplemental brief here. The state does not believe that the constitutional argument is properly raised in response, but even if it were, the equal protection claim fails. These are obviously differently situated, distinguishable individuals. Again, the statute does say that these journal entries can't have been attached to the original PSI. And then there are a number of requests for presumptions here in the supplemental filing. There's no room for presumptions in this statute. It is a burden that the defendant must carry. We don't just blindly presume things, they have to prove them. The place to do that is in the district court. That is the entire point of this statute. I guess, and the final thing that I guess I would conclude on in response to the comment that and recognition that this statute was meant to fix Obregon, that again proves the state's point. We don't want to litigate these complex out-of-state cases for the first time here in front of this court. It takes an abundant amount of time. So an opposing counsel recognizes that, of course, these out-of-state things are what ends up in published opinions and so on. Yes, but we want to stop that. That's what this statute was passed to do, is kick this back to the district court, and then this court can review any success or failure on a claim. If either party wanted to appeal, then at that point. And then finally, one other ambiguity that continues to exist here is the journal entry the defendant provided. It doesn't specify what subsection of the Tennessee statute was provided. So at most, they've posed a potential illegal sentence, a potential claim that either needs to be remanded or that this court should dismiss outright and allow him to pursue at the district court level. I would welcome any additional questions.
Are there any other questions from the panel? All right, thank you very much, Mr. Gillette.
Thank you.
Mr. Randall, welcome back. You have 3 minutes for rebuttal.
Thank you, Your Honor. And maybe it was clear that I don't have a very good poker face, but I disagree with Mr. Gillette wholeheartedly that the purpose of this statute, is to get these things, to not waste the Court of Appeals time and to get this back to the district court, and that's clearly what was proposed. I mean, I struggle to see how that would be the interpretation when The subsection specifically talks about raising the challenge for the first time on appeal. The offender fails to provide it, the appellate court should dismiss the claim. In designating a prejudicial error, I provide the appellate court with this, what the appellate court can take judicial notice of. And furthermore, there's no way in which there's no provision for an automatic remand. The statute is very permissive. It says you can, but that's not necessary when the entry that has been provided pursuant to the statute conclusively shows that there was an error. I appreciated Your Honor's question about how do these three things that you emphasized require the presence of another person. They don't. The crime, I believe the state was indicating that, yeah, these are crimes that occur when you're registering. No, they're crimes that occur when you fail to register. That's what he was convicted of. Failing to go to these places, failure to sign the form, failure to provide the correct information on the form, failure to notify law enforcement. All of these things are a failure, and likely show that there was no presence, but certainly don't necessarily prove the presence of another person, which is what 6811 requires, Your Honors. I think I missed, the state indicated that the things that we get from district courts, there's clerical errors and there's confidential portions. Well, again, the confidential portion is included as part of the record in this case. And when we talk about, well, how do we know whether the district court did or did not consider it? Well, we can look at the sentencing. There's certainly no mention of it, and I would trust our district courts that if there's documents and things that the court is considering, whether first of all, I'd expect that they'd be mentioned, during sentencing, but even if they weren't, that they would be included as part of the record. We have the confidential PSI. There's nothing that's attached to it. So because there was nothing that was attached to it, because we've designated a record pursuant to the statute, this court doesn't need to remand. It can look at the statute, it can look at the journal entry, and it can make the determination here and now, rather than when we talk about wasting time, going back to the district court, providing the same documents and making the same argument that is already, presently before this court. And so I don't.
Counsel, in looking at the language of the statute and the different sentences that we parsed out earlier, is there any distinction that can be made based on documents that are normally attached to a PSI and documents that maybe aren't as commonly attached to a PSI?
I might need some clarification as to what you mean by some certain documents that are generally attached and documents that aren't generally attached. I guess I don't.
I'm trying to come up with some reason for distinguishing between the documents we can take judicial notice of and the journal entry mentioned in the prior sentences that weren't originally attached to the criminal history worksheet. And I'm just speculating, and I'm asking you your position on, whether there's any basis to recognize that distinction in the fact that, normally it's journal entries that are attached to a PSI and maybe not some of these other documents, or is there just no comfort there?
I guess perhaps why the other documents in the fourth sentence are specifically listed is because I would agree that probably verdict forms, I think, was one of the things that is listed, are probably not generally attached to a PSI, and perhaps
jury instructions, verdict forms, plea agreements.
Right, I would agree, but certainly that's not what we have here. We have a journal entry. I find it hard how the document that's been provided to the court couldn't be considered a journal entry. It says judgment at the top. That's what our journal entries are, journal entries of judgments. Full faith and credit clause says that we're supposed to give, full faith and credit to judgments from other states. It's been certified by the circuit court. And again, when you look at, I think, all the different ways and various ways that the statute can be violated, again, none of them satisfy the requirements of 6811. And so I think, again, this court has the ability. That's the statute doesn't. I wholeheartedly disagree with saying that the statute was written so that we're not wasting your time and that this must be done back at the district court. It allows you to remand it, but it doesn't say you shall, because you don't have to in all cases. And Mr. Emery's case is not one of those cases. I've provided the appellate court with documents demonstrating and showing, I think, conclusively prejudicial error. And I think this court can then vacate his sentence and remand it with instructions that he be sentenced with the appropriate criminal history score, which would be an E in this case.
Thank you very much, counsel. Any other questions from the panel? All right. Thank you, gentlemen, for both of your arguments this morning and for all of your written submissions. We appreciate it. They're well taken. We'll take the matter under advisement and issue a written decision as soon as we're able. That concludes this morning's docket, and we're adjourned. Thank you.